This is the last you'll be seeing of me today. I will introduce the moderator for the next panel and then be off. Nathan Sales is a professor at George Mason University School of Law. He teaches, among other things, national security law, to which he brings a considerable amount of practical experience. He served in the Office of Legal Policy at the Department of Justice. He received the Attorney General's Award for Exceptional Service at the Department of Justice. He was the Deputy Assistant Secretary for Policy Development at the Department of Homeland Security. Nathan remains very much in the arena, regularly testifying before Congress and other public bodies, appearing in the media and at events like this. So Nathan, thank you.
Thank you very much, Vince, for organizing this. Thanks to the Federalist Society. Thanks to Jones Day for making this lovely space available. I want to breeze through the introductions fairly quickly and get to the main event, which is a full and frank exchange of views among our distinguished panel, probably because most of the folks, all the folks on this panel need no introduction. So we'll start by hearing from Steve Bradbury, who's a partner at Dechert, who previously served as the head of the Office of Counsel at the Justice Department. Next, we'll move on to Jim Harper, who at the Cato Institute is the Director of Information Policy Studies. He's the co-editor of the book Terrorizing Ourselves, How the U.S. Counterterrorism Policy is Failing and How to Fix It. Next, we'll turn the podium over to Kate Martin, who is the Director of the Center for National Security Studies and 2005 recipient of the Eugene S. Pulliam First Amendment Award, which was awarded by the Society for Professional Journalists. Finally, we'll hear from Ben Wittes, who is a senior fellow in government studies at Brookings Institution and the founder of the indispensable Lawfare blog. So without further ado, please join me in welcoming our panel.
Okay if I speak from right here?
Please.
Okay, great. Well, thanks for inviting me. Appreciate being here. We're going to talk about the so-called Section 215 program. This is NSA's collection of telephone metadata and the issues that raises. I'm going to take just a couple minutes to describe the basics of what the program is, why they do it, talk about how it satisfies, in my view, the relevance standard under Section 215. This is Section 215 of the Patriot Act. It's a provision of the Fisa statute, Foreign Intelligence Surveillance Act. And then touch on the constitutional issues and the analysis of the program, and then under the Constitution, and the major proposals for reforming the program. So I'll try to move through that quickly, and then we can follow up with more in-depth discussion as others join in. The telephone metadata program does not include the content of any telephone calls. It doesn't involve the NSA listening in to telephone calls. It involves a collection just of what's called metadata, which is data about communications, not the communications themselves. And in this case, it's old-fashioned telephone data. It's what phone numbers have called what phone numbers, what time, and for what duration. And they collect it in bulk for not just international communications in and out of the U.S., but for domestic calls as well. But they don't take this database and just troll through it randomly looking for patterns to try to find terrorists and terrorist plots. Instead, their use of the database is strictly limited by the court's order, the FISA court that approves the collection. They can only query or get access to the database when they have a phone number for which they have a reasonable suspicion that it's associated with a foreign terrorist organization, one on a particular list. And then they can query the database to see what other numbers that phone number has communicated with, calling or receiving calls from, and they collect that 2 to 3 hops out, 2 hops for sure, 3 hops if they have a reason to do it, and they get that collection of connections and they analyze it. And what are they doing? Why are they doing this? They're not trying to find out more information about the number they already know about that's associated with a terrorist organization to see who that person is calling, etc., because there's a good chance that number is already under surveillance. They're trying to discover new numbers that we didn't know about before that are associated with that terrorist organization that may be a cell of the organization in the U.S. Critical information to build an investigation from the ground up. This is not the end of the investigation when we know what's up, we've discovered a plot and we're trying to zero in. This is gathering information at the front end to try to inform an ongoing investigation of these organizations. Why do they need to collect the bulk metadata? Well, to do this analysis, finding these patterns and connections and discovering new numbers, they need the largest set of data they can get to see the connections, particularly when you're talking about a number that's outside the U.S. and what other numbers have communicated with it. So they need as much data as they can get, and the problem there is the telephone companies no one telephone company generates all this data. It's multiple companies in different formats, and no company keeps the data for very long. They keep it for a few months. They only have it for billing purposes. So when they resolve billing disputes, they don't need the data anymore, they don't have to keep it, and they don't have the capacity to keep it. So the NSA needs to gather the data in bulk in order, one, to preserve all the data, because the historical analysis is a critical part of this. They see a new number, and they can look back 2, 3, 4 years at plots we were investigating in the past and see this number was used then in connection with that. That's critical information. So they need the historical analysis. And number two, they need to aggregate all the data together in one database to efficiently do this analysis. It doesn't work if it's in multiple databases all over and you're trying to put it together, far less efficient. So they put it in one database in a common format and they preserve it. They do this under a business records order that's approved every 90 days by a Fisa judge under Section 215, the standard of which is the same standard that's used for administrative subpoenas by all manner of federal agencies and law enforcement departments that are doing investigations. The standard is, are the business records that you're seeking relevant, or in this case, is there reason to believe they are relevant to an authorized counterterrorism investigation? Not every record that's collected under the business records order, not every individual call record or piece of metadata has to be shown up front to be relevant to the investigation. It just needs to be reasonable to believe that the data in the database may be useful in that investigation. This is a common standard. The Federal Trade Commission uses it, the Antitrust Division, all manner of federal agencies in conducting investigations use a similar standard for issuing administrative subpoenas to obtain documents and other data. And often they collect large databases where they only have reason to believe that some individual records, they don't know which ones yet, may be useful in the investigation, and particularly when they need to preserve the data for an ongoing investigation. Now, the big difference, however, with the National Security Agency under the Patriot Act and the Fisa statute is I don't know if it's unique, but the big difference is that the NSA has to get a federal judge, an independent federal judge. There's a regular district judge who's assigned to sit on the Fisa court to approve this order and the obtaining of these business records. Other federal agencies doing investigations, some of which are extremely broad and involve masses of data, much of which can involve personal information about transactions of average Americans, et cetera. Those agencies that use a similar standard don't have to go to court to get it approved in advance. They can issue the subpoena on their own authority. Common administrative subpoenas are issued in this city every day, extremely broad in breadth, seeking vast amounts of data and information about transactions that go well beyond any individual transaction that may be relevant to a particular violation of federal law. So the big difference here is NSA actually has to get it approved in advance. And no court has held that this data collection, as vast as it is, violates the relevance standard of Section 215. In the FISA process, 15 different federal judges on 37 occasions since 2006 have agreed that it satisfies the standard. 2 other federal judges have reached the issue and said it complies with the statute. No court, not including Judge Leon, who addressed constitutional issues, did not address the statutory issue. No court has held it exceeds the authority under the statute. Let me talk about the constitutional issues it raises. It's most appropriately analyzed under the Fourth Amendment. And the question under the Fourth Amendment is, first of all, do you have a search? And the standard the Supreme Court has said since 1967 for what is a search is there a reasonable expectation of privacy in the information that's being gathered? And in a line of cases that include the Miller case that involves bank records of check cashing transactions, the Smith versus Maryland case that involves pen registers collecting exactly this type of metadata on telephone calls, exactly the same data, what phone number called what number, what time, and what duration. Supreme Court has said these kinds of transactional records, which are metadata in effect, records of communications or of transactions that are generated by service providers in the course of their business, those are not records that the individual subscribers have a reasonable expectation of privacy in. When you make a phone call, you no longer control what the phone company is doing with the record of that phone call that it generates for billing purposes. Similarly, when you cash a check or use your Visa card, you don't have control over that merchant's record of that transaction or the bank's record of that transaction. And the Supreme Court has clearly said that because you don't have an expectation of privacy in the record, that when government, for law enforcement or investigation purposes, obtains that record for an authorized investigation, that's not a search that requires a warrant under the Fourth Amendment. If it were a search, all manner of regulatory investigations, all manner of grand jury investigations, all sorts of these types of obtaining of business records for authorized purposes to initiate an investigation would require a warrant, would require probable cause. And of course, when you're initiating an investigation and putting together the building blocks to pursue potential targets, by definition, you don't have probable cause at the outset. That's something you develop in the course of the investigation, and then when you do a search that does invade the personal privacy and reasonable expectation of privacy, you have a warrant because you've generated the probable cause based on the preliminary steps in the investigation. This program involves the preliminary steps in the investigation. So because it's not a search under the Fourth Amendment, it satisfies the Constitution. It's consistent with the Constitution. A lot of courts of appeals have followed that line of cases when it comes to email and other more modern technologies. And there's a debate whether when you're talking about smartphones in 2014, they have a richer set of data, et cetera, than what the phone had in Mr. Smith's case in 1979. But I return to the point that here the data we're talking about is exactly the same data as what was at issue in the Smith case, the old-fashioned telephone number data. Finally, there have been a couple of proposals for reforming the program. Let me just talk very briefly about what the President has proposed to do. He has said that he wants to transition the holding of the database from the NSA to private hands, because concerns have been raised about the potential for abuse, even though he affirmed repeatedly, and every body, board, review group, et cetera, that has reviewed this, the intelligence committees that have reviewed it, have concluded that there's been no intentional abuse of the program. Nevertheless, because of the debate that has raged and the concern about the potential for abuse, the President wants to move the database into private hands. And he's charged the Attorney General and the Director of National Intelligence to study whether that can be done. Of course, there's an obvious problem with that, if you just stop and think about it. Who's it going to go to? Whose hands will it be in, and where will it be? Today, it's locked down in the basement of Fort Meade. It's quite insulated and protected from incursions. It's subject to extensive oversight. The court oversees access to it. If it were to move to private hands, it would necessarily have to go to a private contractor. As I said before, no single telephone company can hold all this data, and they don't want to do it. They have no interest in doing it. It will go to a private contractor. It will be held on private servers, probably in a suburban office park, probably just a little ways outside Fort Meade, but it won't be as secure as it is today. It will necessarily be more subject to cyber incursions, potential hacking, et cetera, and access through court orders and private litigation. So the president has said it will take some legislation from Congress to try to secure it, et cetera. I wouldn't be surprised if at the end of the study period it's concluded that that's not a better solution. It's not a viable solution. The one other thing he's talked about is getting individualized Fisa court approval every time the NSA wants to access the database. And the problem with that is that it's moving us back to the model we operated under prior to 9/11. It will inevitably involve a small army of lawyers, court approval, extensive documents. It will become more like a probable cause determination that has to be made up front before the data is used, and that will seriously undermine the flexibility and utility of the database and of the program. And so there's a real question about how that can be done, and I suspect at the end of the day, again, what they will probably do is some kind of mass review and approval of groups of numbers, et cetera, and I'm not sure it will actually be the one-by-one individual review and probable cause-like determination that some of the opponents of the program have been advocating for. So I think I'll stop there, and I'm sure we'll have more discussion on each of these points. Thank you.
Thank you, Steve, very much. Jim, the floor is yours, please.
Thanks. It's a pleasure to be here. Thanks to the Federalist Society, which has long been a champion of good debate about principled matters, which I think is really important, and we'll touch on a lot. I'll try to be quick with a lot of material I want to get across to you. With questions like this, I like to do an orthodox analysis, which starts with whether or not there is a constitutional power for what is being done in this program. Yes, there is. The power to provide for the common defense is well within a federal authority. Very often we talk about things that the federal government has no business doing. So I'm glad that we are going to be agreed, I think, on the fact that this is within the constitutional power of the federal government. The next step is obviously statutory interpretation. And I'll confess that I'm not a 24/7 national security worker. Don't spend all my time on even these issues, but I believe very strongly in the rule of law. And the idea that a person of average intelligence should be able to look up what the law is, understand it, and rely on the laws that are published and available to people. So I'll do my best statutory interpretation as a regular guy, and which I think differs from Steve Bradbury's and many others who support the program. When I went to read what everyone refers to as Section 215, I didn't understand how it could possibly support a program like this. And when we briefed it to the court in an amicus in Ray Epic, Randy Barnett and I spent a lot of time arguing about the literal terms of the statute and how those could possibly square with the Section 215 program as we knew it. And we picked on a couple of things in the requirement for the application to get tangible things. Among them, that the things sought are relevant in the present tense to an authorized investigation. The investigation, that is, that authorized investigation must be authorized in the past tense. So we argued somewhat primly in terms of the language that this language very much presupposed the existence of an investigation. The tangible records could not be acquired if there was not already in existence an investigation. So that was the debate, I think, at the time about the relevance standard. Perhaps as we've moved forward in time, we're starting to realize that it's more like an investigation standard, and we're going to have a debate about what the contours of an investigation are. Coincidentally, and it's a little bit more of that country lawyer thing that I like to fake being, I cited Black's Law Dictionary to the court on what the meaning of the term investigation is. An investigation is the process of tracking down through inquiry, and relevancy is that which conduces to the proof of a pertinent hypothesis. And to my thinking, that might be the most important part of giving meaning to the word investigation, which is that you have a hypothesis, and your work is related to, or I'd say relevant to, proving or disproving that hypothesis. And I think that the gathering of bulk data under the 215 program is perhaps preliminary. It anticipates having hypotheses, and everything that goes on within the program, as Steve described, are that. But whether you can acquire the data in the first place, that requirement a hypothesis. A true investigation is not met. So we continued in our argument talking about congressional intent, which I think cuts against the 215 program. The structure of the statute, I think, also cuts against the program. It bars collection of data for a threat assessment, and there are a couple of discussions or references to threat assessments in existing law, including background checks and general studies, sort of general risk studies. But take background checks as an example. Section 215 bars collection of data for background checks, so it wouldn't allow, again, assuming that the other statutory reference to threat assessment is the same as what was intended in 215. So it wouldn't allow investigation of people who may be taking on jobs in sensitive roles inside the government or out. But it would allow the collection of phone records of retirees in Florida. That seems very inconsistent that 215 should bar threat assessments while allowing collection for what we know now as the 215 program. The 215 program effectuates data retention, which Congress has considered year over year over year over year and declined to adopt in law. And it also creates a constructive pen register. So there's pen register authority elsewhere in 50 U.S.C. section 1842. So the idea that 215 was meant to create a pen register allows the creation of this pen register, I think, is out of step with the structure of the statute. The Privacy and Civil Liberties Oversight Board came up with an argument that I think is very interesting, that the program violates the Electronic Communications Privacy Act. I won't say more than to refer you to that argument, because I think it's a good and an interesting one. They make the point that that ECPA is very specific about for what purposes communications data like this may be collected, and the general rule of 215 would not overcome a specific statute, one of the canons of construction. Now, the constitutional issues are one where I'm, that's an area where I'm most interested in trying to reform Fourth Amendment doctrine, which is quite bad. I declined to answer when we were asked earlier, do you think you have a reasonable expectation of privacy in whatever it was? I declined to answer because I don't even use the reasonable expectation of privacy test in my own thinking. And I encourage you all to try to excise the prefix reasonable expectation of when you're talking about privacy. Many lawyers can't seem to say the word privacy without saying reasonable expectation ahead of time. First, a narrow point, one that I haven't done a lot of work on, but I think it's worth looking at this program as a general warrant. So there are really two parts to the Fourth Amendment. We talk a lot about the bar on unreasonable searches and seizures of persons, houses, papers, and effects, but a separate and freestanding clause bars general warrants flatly. And I don't know that, there may be other readings of it, but I don't know that either of the two phrases in the Fourth Amendment rely on the other. And so a general warrant going as to anything may be barred by the second major clause of the Fourth Amendment. And it would be worth looking into that. But let's talk about Smith v. Maryland and the third-party doctrine. First, I think it's entirely distinguishable. So I guess I can grant, but I object to the relish with which many defenders of the 215 program use Smith versus Maryland in defense of it. Because yes, I suppose you're allowed to take a precedent that has plausible application to the current case, but you really should actually have your eyes up and eyes on the horizon, awareness of changes in technology. And maybe changes in privacy expectations or what have you. It's clearly a factually distinguishable case. If you don't know the facts by now, you should. But in the case of Smith v. Maryland, a woman was robbed, and the person who robbed her started calling her and obscene and threatening phone calls. She had identified him as a driver of a 1975 Monte Carlo. And on one of the calls, he said, "You should come outside. I'm going to be, near your house or something." She goes outside, once again sees the 1975 Monte Carlo, describes it to police. They find the car, take down the license plate, use the license plate to identify who their suspect may be, and they ask the telephone company, which voluntarily places a pen register on his phone. After he makes a phone call to her house, confirming their suspicion that this is the guy who's the likely burglar and the maker of obscene phone calls, they could use that information to get a warrant. Upon searching the house, among other things, they find a telephone book with the corner corner of the page turned down to the corner turned down on the page that has her number on it. Well, in this case, when he fought the use of that telephone information, the court found that he had no Fourth Amendment interest in that data. One case of a person who's quite plausibly suspected of committing a burglary and making obscene telephone calls does not, in my mind, equate to the same application of that rule to all of our telephone calls every day, or most of our telephone calls, whatever dimension of success the program is having at gathering telephone calls, because we are not suspected of anything. The context is entirely different. The ability to collect, process, and use the information is vastly, vastly different than it was in 1979 when Smith versus Maryland was decided. The case was also wrongly decided. And as a literal matter, the court skipped over part one of the Katz test. Most courts do, and I suppose it's forgivable. That's the question whether the individual had a subjective expectation of privacy in the information in question. But I also think it got part two of the Katz test wrong. That's the question whether it's objectively reasonable. That's whether society is willing to accept the expectation of privacy that the defendant supposedly held. Read the Smith versus Maryland case, and you'll see that, I apologize, I forget which justice was the author, he didn't even consider any counter-arguments to the idea that people have no expectation of privacy in this information. It's an entirely one-sided discussion. And because it's a conclusion of societal sweep, I think any of us are entitled to say that the court was wrong in making this judgment, because it is a judgment of societal sweep. It was based on no research, it was based on no studies, and the Katz doctrine actually invites courts to make broad societal judgments that it's really incapable of making. Katz doctrine is wrong, and you should all stop relying on that too. The reasonable expectation of privacy test should go away. Justice Harlan, in his concurrence to Katz, was basically vamping, trying to figure out what the heck was going on, and he didn't do a very good job. The reasonable expectation of privacy test basically reasons backward. It says, well, if there's an expectation, then we're going to find Fourth Amendment privacy. But the way to reason forward is to look and see whether information was private or not, and then see whether the government's acquisition of the information was reasonable. So understand what privacy is in the first place. Going back to at least 1967 and a book by Alan Weston called Privacy and Freedom, it's really been understood as control of information about yourself. And I talk about privacy for legal audiences like this. You might actually have a good time with this. Privacy is the subjective condition we enjoy when we, one, have the power to control information about ourselves, and two, when we exercise that power consistent with our interests and values. But take away the fact that it's control over information. The steps you take to control information, even things you do every day by putting on clothes, for example, put you in the privacy condition you enjoy. Obviously, the online environment makes it very hard to protect privacy, and the technology is constantly changing, so many people are going around online essentially without clothes on. But they will learn over time, hopefully, to conceal the information they want to keep concealed. If you reason forward in terms of the Fourth Amendment and privacy, the question then the Fourth Amendment raises is, was the government wrongly defeating the privacy protections that people had established for themselves? And the question I would ask is, was there a search, sort of like a statutory way of treating this law, which is supposed to be a law? Was there a search? Was there a seizure? If there were either, was it reasonable? The great search case is Kelo, which is the case in 2001, I believe, where law enforcement in Oregon used a thermal imager in order to perceive heat emanations from the side of a house. They basically took waves that were invisible to the eye, and using a newfangled device, they converted those waves into something visible. Justice Scalia found that to be a search. The Jones case 2 years ago was a seizure case. So the court unfortunately referred to it as a search, the application of a GPS device to a car and then using it to track someone for 4 weeks. They called it a search. But the gravamen of the complaint that the court talked about was attaching the GPS device to the car, an invasion of the privacy right, the right to exclude, if you want to think in terms of the law school era bundle of sticks. So the way that the Fourth Amendment should be administered is as a statute. Was there a seizure? Was there a search? Was it reasonable? This is judicially administrable because you have questions that are essentially factual. You have questions that are tightly legal. Many times we protect privacy not only with physical barriers, but with legal ones. We require people to maintain confidentiality in information we share with them. Regulations often require confidentiality of information. And in fact, the data about people's phone calls is called consumer proprietary network information. It's a form of property, and information I believe can be property that falls well within traditional notions of Fourth Amendment law, if perhaps extended to understand how the modern technological environment works. I'll close by talking in terms of policy considerations, but policy judgments are very hard to render in this area. I think most people actually, though, you know the old saying, actually, that a lot of differences are about premises. A lot of us are debating the terms of the 215 and how it applies. But the real differences of opinion are based on premises. And I think the premises that divide people are really what kind of threat we face. When I was a child, I remember very well that we would, in school, do duck and cover drills, jumping under our desks and covering our heads, perhaps lamely, at the prospect that a nuclear weapon fired from the Soviet Union would fall somewhere in the vicinity of our homes. And we imagined that a light off in the distance would be the signal of our instant demise. And if we weren't so lucky, the prospect of living for some decades in a nuclear winter. And I was mortified by 9/11, of course. I think it was horrible and shocking. But having studied terrorism for a number of years since, I'm relatively sanguine to that threat in comparison to the one that we faced from the Soviet Union, with tens of thousands of nuclear warheads aimed at the United States. So there's no argument that terrorism is not a serious challenge, and it's a complicated challenge. We might wistfully imagine the days of the Cold War as wonderful because it was so simple. We had a single enemy, really easy to figure out who it was. But I don't think that we should be so scared of complexity that we think that the Soviet times were not very dangerous compared to today. We will see terrorist attacks again. I think they will be pinpricks on society of the kind that we saw in Fort Hood and Boston, regrettable though they are. They pale in comparison to many other causes of morbidity and mortality around the country. And rather than talking about feelings, I've just talked a lot about feelings, I'd rather for the next era of debate about these programs to really be in the area of risk management and cost benefit. How much does the 215 program cost? And is it cost-effective security? I don't know that there are any studies in this direction. I know that questions have been pointed this direction in a few places, and I know that security agencies of all stripes are resisting very hard against asking and answering those questions because they might not get the answer that they want. But they're essential if we're to have a better discussion of these issues. It may be, as Oliver Wendell Holmes said, that the life of the law is experience and not logic. We need to know more about the threat problem. Thanks.
Thank you, Jim. Ms. Martin, please.
Thank you. So, following up on what Jim said, I want to try to outline some specific questions which I think the Congress and the public and the intelligence community will need to answer about going forward. But before I do that, I want to speak briefly about where we are and a little bit about how we got here on the 215 program. And I want to just add one important fact to Steve Bradbury's description of the way the program works. As everyone knows, it works to authorize the government to collect all of the telephone metadata on Americans' phone calls from whatever telephone companies they go to. When they collect that data in a database, they can only query it with a number, telephone number, or some other kind of identifier for which there is some suspicion that the number is associated with a specific terrorist group. But what the other part of the program, which has not been mentioned, which I think is as troubling as the first part of the program, is that the results of those queries are then put in a different database at the NSA, and the limited rules about using the information no longer apply. And so the Privacy and Civil Liberties Oversight Board estimated that if you're talking about a telephone number that is in contact with 75 telephone numbers, and then there's another 75 telephone numbers on the second hop, et cetera. Anyway, that something on the order of 1 million call records are moved out of the limited database into the general NSA databases every year, which can then be accessed under an entirely different set of rules for any foreign intelligence purpose and not limited to counterterrorism purposes. So I want to make what might be a provocative statement, which is that I think we made a lot of progress from the standpoint of civil liberties since the disclosures by Edward Snowden. And I think that there are 3 ways in which that's happened. One, we've had extensive official declassifications of information about the program and the legal authorities, so we now know what we should have known all along. 2, the president has, in fact, already limited the program in a way that I'll detail in a moment. And 3, we are now having an informed public debate about what kind of authority the government should have to collect the metadata on Americans' phone calls. We should have had that debate many years ago, but it's better late than never, right? Before outlining the specific questions that I think Congress is going to have to look at, I do want to note that I think it's important not to forget that this program was started, in my view, in violation of basic principles of democratic process. That the basic principle of democratic process is that our elected representatives are charged with deciding what kinds of authorities the government will have, not, quote, to collect foreign intelligence, which is stating the problem at a level of generality that doesn't get us anywhere, but the issue on the table is what kind of authority should the U.S. government have to collect information about Americans, and under what circumstances, et cetera. This, the collection of metadata on Americans' communications was started in secret after 9/11 and was started outside of any statutory framework at a time in which there was a public debate about what the statutory framework for government surveillance should be, but the Bush administration deliberately kept this subject out of the discussion about what that statutory framework should be. After some number of years, it decided that it made sense, or that it was basically after the press started to write about the surveillance which was being conducted outside of the statutory framework, and in my view and the view of others in violation of the statutory framework, that it made sense to move the surveillance within the statutory framework. But, so this happens in 2006, as I'm sure some of you will recall. Not only was that the moment when the New York Times had revealed the warrantless surveillance program, it was also the moment at which Congress was considering renewing the Patriot Act and Section 215. So while there was an enormous debate about Section 215 and what its provisions should be, and there were hints in newspaper articles about the government's collection of metadata on Americans' domestic communications, which was what was in fact going on, but was never confirmed by the government until December, I think, 2 months ago. There was no discussion with the American public, nor with Congress as a whole, that if Section 215 were renewed and amended, that it would give the government the authority to collect all of the metadata on all of Americans' communications, not only telephone calls, but internet communications. So thankfully, we are past that, and there may even be some recognition that some of that was a mistake. So where are we now? As I'm sure all of you know, the president gave a speech in January about the NSA surveillance in general, but and with some particular comments about Section 215. So, and one of the things he said was that he wanted the capability that the intelligence community has under the program to be preserved. And so one of the issues for us as lawyers is to understand precisely what that capability is. So you heard Mr. Chertoff, I think, say that it would operate to let the intelligence community know with 100% certainty whether or not a foreigner who's a terrorist suspect has been in touch with an American in the United States or a non-American in the United States. That I don't believe is correct, and I don't think that any of the official descriptions of the program support that. What the program does is it gives the intelligence community some information about whether or not someone overseas has been in touch with someone in the United States. If someone overseas is in touch with someone in the United States through the internet rather than through telephone calls, that information is not disclosed by this program. And we've also learned recently that the program doesn't cover all telephone calls within the United States. So right there's another hole in coverage. So what you have is a capability that gives you some information, but not all perfect information about contacts between people overseas and people in the United States. But the other part that's important to remember is that this is not the only tool that gives the intelligence community that information. And in fact, both the FBI and the NSA have myriad other authorities and programs which give them access to information about who's calling who between the United States and abroad. So, one of the questions I think that's raised by this is, given the kind of limited capabilities or the capabilities that exist elsewhere, is there something else going on with this program? Is it actually useful for more than they've told us about? But that's a question that we don't have the answer to. We now are faced with the president having decided to limit the program in 3 ways. First of all, the president directed that the intelligence community, instead of getting 3 hops when they query the database, will only get 2 hops. That, as I understand it, has already been implemented by the intelligence community. The program's already been limited in that way. Secondly, the president directed that instead of the NSA deciding that there was enough suspicion about a particular number before using it to query the database, that the NSA had to make the case to the Fisa court that there was enough suspicion for that number, and the Fisa court would have to make that determination. That has also already been implemented, and just in the last few days, the Fisa court order implementing that and saying we will make that determination has been declassified. And thirdly, he directed that the NSA no longer collect all of the telephone metadata on all Americans, and that instead the government figure out an alternative technological means so that they can still run the query with a seed number without having the bulk collection. So I believe that there are interim measures that the intelligence community can take, given the fact that all of the telephone companies right now keep records for some only, a few only for a few months, but some large telephone companies already keep the records for 5 years, and the government itself has a large database. So that leads us to the question of what's going to happen next. The lawsuits challenging Section 215, I think, will continue, and that ultimately we may or may not have a decision on whether or not the statute authorized the program and whether or not, if so, the program is constitutional. But in all events, Section 215 is sunsetted in the middle of 2015. And so Congress, thankfully, can now ask and debate the questions that it should have asked and debated in the last 10 years. And I want to just quickly list those, if I have time.
Absolutely.
Okay. So I think one of the initial questions is whether or not the NSA, rather than the FBI, should have the authority to collect metadata on Americans' telephone or internet communications. This is actually a pretty important question. It's not been talked about as much as it might be. I think the second question would be what kinds of call data should the government have access to? Should it have access to call data? What kinds of metadata? Should it have access to metadata on internet communications as well as telephone calls? Should it have access to location metadata? Right now, it doesn't get location data under 215, but as I read the government's interpretation of Section 215, it would presumably have the authority to ask for that location data if it wanted to. And one might also ask whether or not we want to treat data about communications between the U.S. and overseas differently than data about communications that are just between 2 points inside the U.S. Then, of course, you have the question of what should be the standard for getting call data on any particular phone number. I think there's no doubt that Jim and I and everyone else in the civil liberties community would agree that, if the government has probable cause that a telephone number is being used by a terrorist or that it can go ask for the telephone numbers associated with that telephone number. And the question is whether or not there should be a lower standard, reasonable articulable suspicion. What should that standard be? Then the question is who should determine that the standard is met? At the moment, under Section 215, as understood by the government, the NSA can determine it for itself. The president's decided that as a matter of policy, the court should determine that. And one of the questions before Congress will be whether or not they should require that the court make the determination that the standard for access has been met. Another question that the Congress has to decide is what can be collected, how far out. If you meet the standard for collecting the information on a particular call, are you entitled, is the government entitled to get 1 hop, 2 hops, 3 hops, and under what circumstances? And going back, how many years does the government need to go back? How many years Does it make sense to let them go back? And going forward, how long? And what are the procedures that the government should use to do either of those? There's the complicated question of what can be done with the data once it's collected. Should it be usable for foreign intelligence purposes generally, or should it in fact be restricted to counterterrorism purposes if that's the reason why it's the government collects it to begin with? How can it be combined with the myriad other databases that the NSA and the FBI have? This is a subject we haven't talked about very much. What are going to be the rules for disseminating the information or combining the information with all of the other electronic data and all of the other electronic databases? And then there's the question which relates to the issue of challenging the collection in court. The significant difference, and this is my next to last one.
Next to last.
Last. I'll make it the last. There's procedural safeguards, which I find too boring to talk about in any great detail right now. So, is the difference between administrative subpoenas for business records and 215 orders is that they're secret. And the secrecy means that there's, first of all, you don't ever know that the government has gotten access to information about you, which is generally not true on the criminal side. You may not know immediately, but sooner or later you know. And that the effect of that means that there is no truly adversarial adjudication in which the person whose information has been collected gets to go to court to challenge that collection. And I think we need to have a conversation about whether or not there's a way to provide for that kind of adversarial adjudication in at least some cases while still protecting the necessary secrecy of foreign intelligence investigations for the time during which they need to remain secret. Thank you.
Thank you very much, Kate. And finally, we'll hear from our cleanup batter, Ben Wittes.
Thanks very much. I'm going to be very brief. You guys have sat patiently through a lot of panels and a lot of time, and I'm not going to take up a lot more. One of the advantages to batting cleanup is that you get to tear up everything you thought you were going to say and simply address things that come up in the course of other people's remarks, which is what I'm going to do. So pardon me if this is a little bit disjointed. But I want to talk about three things. The first is the difference between thinking in terms of programs and thinking in terms of capabilities. The second is a program that we actually haven't talked much about in this panel, but is dramatically more important than the 215 program, and that's the 702 program. And the third is the legislative politics of those two things put together, combined with some of the default options of inaction to which Kate alluded when she referred to the sunsetting of the 215 program, I believe in May of next year. So let's start with capabilities. It probably stems from a combination of the fact that a lot of the conversations about these issues have taken place at the hands of lawyers. It also has to do with the structure of the leaks themselves, which what was disclosed was initially about the 215 program was a single order, ordering a single company to produce stuff pursuant to 215, which immediately caused everybody to think in terms of program. What is programmatically being required to happen, right? And what is it being used for? And the result is that we have a lot of conversations over the last 6 to 8 months that sound a lot like this one. I just want to, at the risk of caricaturing my co-panelists' remarks, I'm going to do so. We started with Steve, who made a case for the legality under the statute and under the Constitution for the program, right? And then we went to Jim, who made a case against the legality under either the relevant standard or under the Fourth Amendment for the program. Kate talked a little bit about the capability, but we start by our reflex is to talk about 215 as a program. Now, it may come as a shock to a lot of the people in this room, but intelligence people actually generally don't think in terms of programmatic legal activity. They think in terms of capabilities. And that's partly because they're not lawyers, by and large. But it's partly also because they're actually chiefly interested in what they can do and whether it's useful. Now, this is not to say that they're lawless, which is not what I mean and not what I'm saying. To talk about something in terms of capability rather than in terms of legality at a programmatic level is not to suggest lawlessness. The DC police and the FBI have the capacity, have the capability to be battering down my door right now. They have these things called battering rams that they use, when they need to batter somebody's door down. That doesn't mean they're doing it, right? That doesn't mean they're behaving lawlessly. But when they think about, what do we need in terms of when the U.S. Marshals need to go into somebody's house to take a fugitive, they think in terms of the capability to do that often before they think of what are the legal circumstances in which you would use that capability. I think the issue with 215 is very worth starting with the question of capability rather than starting with the issue of the programmatic activity and the legality of it. And the capability question very simply is this. When you come across a phone number that you reasonably believe to be associated in a meaningful sense, and you can articulate the reason why you believe that to be associated with an overseas terrorist group, should we have the capability to plug that into a database and get an answer to the question, which other phone numbers have that phone number been in contact with? Should you be able to do that really pretty easily? And should you have the capability, if that's an overseas number, to do it at all with respect to the question which numbers in the United States has that number been in contact with? If you believe the answer to that question is yes, that is a capability that is actually worth having, then we've actually cleared away a lot of the brush of the question of whether we should have a 215 program. And the only question remaining is the question of whether we should have the particular iteration of the 215 program that we've had for the last several years, whether we should have the version of it that the president has proposed, or whether we should have some version of it that is, more constricted than that one. So what I would say is, instead of focusing on the question, let's start with an elaborate statutory, an elaborate FISA court implementation of a program based on a relatively spare statute and a whole lot of Smith v. Maryland discussion. Let's start with the capabilities question. Is this a capability that you want? And if so, what do you think are the circumstances statutorily, technically, and in terms of the burdens on the intelligence community and the phone companies in which this capability should be deliverable? That's point number one. Point number two, 215 is important, but it's not very important. So 215 involves, we focused on it a large amount as a society because it's comprehensive, right? They purport to be collecting, although now we learn that maybe they're not actually collecting, but they purport to be trying to collect all domestic records of all telecommunications exchanges. And that's, dramatic in its scope. But if you look at the number of queries of the database, it's quite small. It's not and if you talk to people in the intelligence community about, what programs are playing big roles and what programs are playing modest roles, this is not one of the most important collection regimes around. It's important in the people who believe it's important I believe it's important because it plays a very specific role, kind of role, in a very specific type of investigation. But it is, in the broad scheme of things, a relatively small program. 702 is not a small program, and it is the bread and butter of a huge amount of what NSA does. And so it is really important, as you think about the 215 debate, to understand that 215 may be distracting you from the actually important debate, which is a broader question of lawful production of communications contents under 702 and the circumstances in which we do and don't allow that to happen. The consequences of this, for what I'm about to say, are twofold. First of all, whether to some degree, and I say this with some cognizance of the fact that I actually love that they may be missing the train on this, but that the attention that the civil liberties community has given to 215 is actually modestly convenient for those of us who believe in robust intelligence collection authorities, because there's actually it actually diverts attention from what I think is sort of the most important stuff that people like me want to protect. But more importantly, I mean, the first question is just whether as a society we're kind of talking about the less important thing and not so much about the more important thing. And whether, number two, that actually reflects a high degree of social comfort level, or at least a relatively high degree with consensus, about the core of what NSA is actually doing, including under the Fisa Amendments Act provisions that were supposedly the most controversial stuff. And so I just hold that out as a question, whether the focus on 215 is really masking a greater degree of consensus than we knew really existed. Number three, I want to talk briefly about the legislative politics of this, and to amplify on something Kate said, which I think is very important. The default options change shortly. Right now, if you fail to get legislation, what that will mean is that the president's authority, assuming you don't have a judicial intervention, the president's authority to do what he wants to do with FISA court approval under 215 remains untouched. And that means the program can continue, and it continues subject to whatever revisions he may choose as a policy matter to make to it. But if he chooses to go back to the harder core version of it, he's free to do so. If he feels wants to revive the internet metadata program, can convince the FISA court of that, he's free to do so, right? If you don't do anything, you're maximizing presidential power right now for another 18 months or a little bit less, right? And at that point, the default options change. And the default consequences of not doing anything at this point become that the Patriot Act authorities on which, including 215, vanish in a puff of smoke or turn into a pumpkin, depending on what your preferred metaphor is. And those programs then disappear. And so I think the power dynamics that creates are important to dwell on a little bit. In the short term, the president has a huge amount of bargaining power. In the long term, the critics of the programs have a huge amount of bargaining power. And the question of, so in a sane universe in which Congress is a functional institution, that should argue for something that didn't used to be a hard thing to say this close to the Capitol, which is, legislative compromise and doing business, right? But in the world in which we live in, where Congress doesn't like doing the easy stuff, like, keeping the government open or, having a debt ceiling amendment when needed to, That's actually, it's not to my mind a foregone conclusion at all which direction this plays. Does it cut in the direction of maximizing the president's latitude? Or does it cut in the direction of stasis and inaction that in the short term maximizes the president's latitude with programs that then suddenly disappear in a puff of smoke? One more thought, and then I'll shut up. Actually, no more thoughts. I'm just going to shut up. Thank you.
Thank you, Ben. Thank you, and everybody on the panel for that excellent set of introductory remarks. I think we have a number of issues now that are teed up for further exploration. We've heard a wide range of views on the statutory questions. Are entire databases relevant within the meaning of Section 215 because they contain information that may be useful to a current investigation, a future counterterrorism investigation, and so on? We've also seen widely diverging views on the underlying constitutional questions, both as to what the current state of the law is and whether current law has been correctly decided and correctly applied. Does the third-party records, third-party doctrine justify acquisition of this metadata on the theory that you have no reasonable expectation of privacy in the phone records that Verizon warehouses? Let alone whether Katz and Smith, the underlying precedents here, were correctly decided. And of course, we have a whole host of different views on where we're going in the future. What will legislative reform look like? What will internal executive branch reform look like? So with all that stuff on the table, I want to lead us through a 15-minute conversation or so before opening it up to questions from the audience. Let's look at some of the statutory questions first. In particular, I want to look at the relevance question. So, Steve, you argued that the relevance standard is actually a fairly commonplace standard in criminal law, with grand jury subpoenas, with administrative subpoenas. Does the 215 authority, does the 215 capability or program, if you will, bear enough resemblance to those garden variety criminal authorities and administrative subpoena authorities that the relevance standard actually does some work, that the analogy to the relevance standard does some work here? Let me actually hear a critique of that view first, and then we'll turn it back to Steve to defend that argument. So I guess I'm asking Kate and Jim, do you find the relevance standard's commonality here a mitigating factor?
You know, on the simplest level, the government's argument is, well, when we use grand jury subpoenas, we frequently ask for a large set of documents because in that set of documents we'll find the specific documents that are, quote, relevant to our investigation. I think when the Deputy Attorney General was asked whether or not there had ever been a grand jury subpoena for all call records of all Americans for the last 6 years, he said no. And just as, you know, it's very hard to, really the government's argument is that what's relevant, we're not going to determine relevance until after we've taken everything. And so I don't think that that's what 215 intended. I think one of the ways you can tell that 215 didn't intend that is that it's a grant of authority to the FBI, not to the NSA.
So how about that, Steve? Does the volume of the data acquired by a 215 order require us to rethink the relevance standard here?
No, I don't think it does. The question is, can the scope of the records being requested ever be, just as a starting point, ever be broader than simply those individual records in the database that will turn out to be useful in the investigation? And so that's kind of step one, and clearly the answer to that is yes, because we don't know in advance what particular records are going to turn out to be useful. So the question is whether the body of records, the category of records you're requesting, is needed for the investigation. Is it necessary? Here, it's essential to have the the full database in order to be able to use the database as a tool in the investigation. And it's a critical tool to the investigation. So the courts concluded that acquiring the database is relevant to conducting the investigation. And if you think about it, this is not uncommon. For example, if there's a regular civil litigation, okay, and there's a discovery order, one party asks the other party to produce relevant documents. Those can be very broad. They can get entire categories. Moreover, the other party will have an obligation to preserve an entire database, the vast bulk of which is not relevant to the specific issues in the litigation, but you have an obligation to preserve it. The NSA right now is preserving all of this data because of these lawsuits that have been filed challenging this metadata collection, because some individual records might show that individuals who are challenging it had their records in the database, and so the government believes it has an obligation to keep them. That's essentially a relevant standard. There are many examples. So, for example, you have a criminal investigation, and a law department will ask for records from all the gas stations on a particular highway for hundreds of miles because they know the stolen car was transported from city A to city B, and they want to find that one transaction in that one gas station where the perpetrator of the crime may have stopped to buy gasoline. But not all of the records of gasoline transactions in that whole region are directly relevant, but they need to get them all to find the record. It's a similar standard, and there are even broader examples in regulatory and homeland and homeland security. I will say the vastness here is clearly unusual and broad and extraordinary, and I think that's explained by the mission of the NSA to protect the United States, the most paramount of importance in terms of the purpose served, and I think that's a factor in the reasonableness of a particular subpoena, for example, but not to the relevance question.
So I remember very well as a document clerk in a law firm before I went to law school, seeing the medical records of a CEO of an agricultural firm in Southern California, and it was not information anybody wants to know about. But he had alleged in the lawsuit that he had suffered some emotional trauma leading to medical with medical results due to some business dealings. And because of that, I'm seeing the fact that he's got problems in his southern hemisphere. But it was relevant to a pertinent hypothesis. There was going to be, at some point in this case, some discussion of his medical situation, and so all that stuff was in. I think Steve, I was listening very carefully to Steve's words, and the thing that the Section 215 program, the data pertains to, is a mission and not an investigation. And I think that's the problem. And I'm actually curious to know if anyone on the panel does, whether there is an investigation in the singular to which the collection of everything is relevant, what its name or identifying number is, and what the pertinent hypothesis is.
The answer is yes, not just one, but dozens, if not hundreds, of open, authorized FBI investigations of the particular foreign terrorist organizations that are on the list. And a threat assessment is excluded under the statute because that doesn't rise to the level of an investigation.
So you won't be able to tell me the pertinent hypothesis of each and how the retirees' phone numbers
I don't really know
are.
what you mean by pertinent hypothesis. The hypothesis, I guess, if you will, is that these foreign terrorist organizations pose a threat to the United States. A big part of the FBI's mission is to investigate those organizations to try to find those threats and prevent them from happening before they hit the U.S. That's the hypothesis, that's the mission, and the question is the collection of these records and using the database to try to discover new phone numbers.
I'm asking about the collection of the data in the first place, not the using of the database, which comes later.
Well, the question is, my analysis is that the database is essential to the investigation because it's one of the only ways to discover these new phone numbers. So therefore, the collection of the database and the assembly of it in order to be able to use it is relevant to the investigation.
Ben has been waiting patiently to weigh in on this, so let me ask him to share his views.
Well, I would just say very briefly, so this is a perfect example of why debating this entirely in terms of the extant statute is very convenient for legal argument, but actually is a bit of a distraction as far as I'm concerned. If you believe that this is an important capability, the fact that it may or may not gel perfectly, elegantly with the word relevance is an argument merely for congressional refinement of the authorization for it. And if you believe the capability is destructive and dangerous and inappropriate, Congress has had numerous opportunities, and members are rushing to pretend they were never aware of what was going on, but in fact members were exactly as aware as they wanted to be of what went on, and they reauthorized the word relevant, knowing precisely that it was being interpreted in exactly this fashion. And so I think the if I may, relevant question, unless you're litigating the particular program under this particular statute, the much more relevant question is, what capability do you want authorized in this space, if any, and what statutory language should you have to authorize the capability that you in fact want to engage in?
So I agree with Ben that those are important questions, but I think you're overlooking why the question of current authority under the relevance standard is really important. And the reason has to do with the rule of law. Section 215 is a public law that was read and interpreted by all of us. And everyone on the outside did not understand that the word relevance allowed the government to get all of the metadata on all phone calls and all internet transactions. And that's why this is really important, because it goes to the question of, are we going to have laws which are written in a way in which there's a public understanding of what authority they've given to the government, and so some public debate about what authority the government should or shouldn't have.
So at the risk of being entirely complacent on that score, I want to say that I actually have, even if Jim and Kate are right, and the relevance language cannot reasonably be said to support the current work that it's doing, I still don't really have a rule of law problem with the way this program has progressed. And the reason is the following. The government developed a legal theory in good faith to allow it to do to engage in a capability that it felt was appropriate and lawful under the statute. It went to the relevant judicial body, again, no pun intended with the word relevant, it was statutorily directed to go to with such requests. That judicial body, 15 times and counting, has reviewed those orders and granted those orders. If ever there were a reliance interest created by repeated action and judicial action done in good faith, courts even if you think the court is wrong in its interpretation, courts get things wrong all the time. And the way we have as a society of dealing with that is that Congress says, actually, we don't like that interpretation, and they change it. And in this case, Congress twice looked at this interpretation and said, fine with us, and re-ratified it. Now, at this point, something became public, and there's a debate, and we're going to revisit this. But this does not strike me as a rule of law problem. It strikes me at the most as, well, Kate and Jim disagree with the FISA court's interpretation. And by the way, I may too.
So I just want to say that I think Ben's outline is a view that's extraordinary and unprecedented. Cite me another example where we had a public law about what kind of authority the United States government had to collect information about Americans that was secretly interpreted by the Congress, by the courts, in a way that the public had no idea of, and in fact was basically misled about, and that's somehow consistent with the rule of law. And for the government now to make the argument that Ben just made, that because it was secretly agreed between the Congress and the courts that they would adopt this interpretation, that's somehow consistent with the rule of law, I find astounding. And I don't think there's another example of Congress and the courts interpreting a law on this particular kind of subject in a way that's kept secret from the public.
All right,
let's spend a couple minutes thinking, if we can, about what will come next.
Can I say one thing?
Please,
so
please.
I think let me recommend to all of you the Privacy and Civil Liberties Board report, because it goes into this question of whether Congress ratified. But I think Ben did a service by suggesting that we get out of the boxes we've been in, and the question of capability as opposed to program. Unfortunately, what I'll do in response is probably some legal hair splitting over the concept of capability. So we'll be right back in the box in a sense. But I wrote a thing. I wrote a thing several years ago, just a blog post. It's not the deepest thing ever, about how to reduce friction in warrant applications. Why not, said the information policy guy at the Cato Institute, create a system where you can apply for a warrant online, lock it down to the extent it's possible, send it to a judge who in minutes can review the application, return it to you. You can send it to the objects of the application, and there's a relatively small number of recipients of the warrant once it goes out. You can set up systems. So if I want to get from Google these types of data from them, I want to get from Verizon these types of data from them, et cetera, reduce the friction so that legitimate warrants can go out fast. Well, the only response I got was from people, it's not to the right, because Cato's not on the right, but further out on the libertarian spectrum, accusing Cato of being a shill for the state when I say things like that. But there's a capability. It's a real capability. It's not what's in the 215 program, and I think Ben may not think that that's enough capability, but real warrants served in real time is right down the line for me.
Let's talk a little bit about what the capability or program could look like on a going forward basis. So Kate mentioned some of the reforms or changes, if you will, announced by President Obama. So we're going from 3 hops down to 2, a requirement of ex ante judicial approval before querying the database rather than leaving that to the NSA in its discretion to make a determination of reasonable articulable suspicion, and shifting responsibility for warehousing the data from Fort Meade to the private sector, whether that's the telecoms themselves or some third party. Let me ask Steve, do you think these sorts of shifts will come at an unacceptable operational cost? Will the program be as effective, as modified as proposed by the president? And let me ask the opposite question for Jim. Do you think those reforms go far enough in protecting privacy and civil liberties?
Well, I think I already addressed this to some extent. I do think it would seriously degrade the flexibility and utility of the program. First, to require NSA to go to the court each time it wants to touch the database is going to put a whole new layer of lawyering in. It's going to impose a very legalistic judicial framework on a reasonable suspicion determination that's modeled more after the cop on the beat, making a reasonable suspicion determination. It's meant to be made by professional intelligence analysts, not by lawyers and judges. So inevitably, when you introduce the requirement of lawyers and judges screening it, you're going to get dozens of pages, if not hundreds of pages of submissions. It's going to be a delay, and it's going to put some real barriers in the process. And so it's clearly not going to be as flexible. So we have yet to see whether the president's proposal, how this is actually going to be done, is going to involve individualized approvals of one number at a time or groups of numbers or something. I suspect they'll settle on something that's relatively streamlined, but it'll still be significantly slower. The second thing is the third hop. As I understand it, they do up to 2 hops in the regular course, and then the third hop only if they have a good reason to do it, only if they see something that leads them to think they need to do it. So why would we needlessly forego doing that? Just to try to make us feel better when we're essentially leaving on the table potentially useful data, information that could inform an analysis to find some of these new numbers, as I say, that we don't already know about. And if we have to go back to the Fisa court to get that approval, again, it's impeding the usefulness of the program. And then shifting the data to private hands, as I said, it's going to introduce all kinds of new risks, both to the privacy of the data, the potential for cyber incursions, also the potential for abuse of the data, because the people who are going to be accessing it are going to be the employees of contractors, not government employees in NSA. They're going to be less susceptible to effective oversight by the court and by Congress. So I think it's going exactly the wrong direction. And even from opponents of the program or those who question it, for example, in the judiciary committees in Congress, I don't see support for putting it in private hands. So at the end of the day, I think that may not be a solution that actually occurs. So I'll leave it there. There's a lot more to respond in terms of some of the points that have been made, and maybe we can continue the discussion.
Right. So I don't think those reforms are near enough. I agree, frankly, that trying to do this with a third party is probably a loser in terms of the security of the data and thus the privacy. I don't know that the 215 program is shown to be cost-effective security, and so I tend to agree with the Privacy and Civil Liberties Board. They're mostly arguing on the legal merits, but I think on the substantive merits of what security provides, that's not shown. So the evidence isn't there for the program, and the burden of proof is on the government to show that the program is something that makes us better off and not worse off.
Okay.
So just a clarification, the records that we're talking about are already held by the telephone companies. It's not a question of moving them into private hands. And if you look on Senator Markey's website, there's a letter detailing the amounts of time that all of the telephone companies keep different call records, and it's years.
I would, by the way, withdraw the data retention mandate that the FCC puts on telephone companies of 18 months. That's their minimum currently. It was put in place for consumer protection reasons because people need to be able to dispute their bills. But I think as a natural matter, they'll keep it for a long time. But if we want a free market in telecommunications, that would be one tiny step.
So we're actually at 3:33 right now. However, unless Vince tells me we don't have time for 2 questions, I would like to open up the microphone for audience questions of our excellent panel. So feel free to voice your concerns or ask your questions. No? In that case, Professor Margulies, yes.
Taking advantage of this excellent panel. I'll ask the question. I'll focus on Jim, but I'm happy to have all you guys respond in terms of the dictionary definition of relevance. I hear you talking about Black's Law Dictionary. My understanding, though, is that is an evidentiary definition of relevance. And there are other definitions we use for discovery. For the discovery function, courts will regularly say that the definition that we use for relevance is far broader. If they don't say it's broad, then they make sure to say that it's flexible. That's a mantra in the cases. So it seems to me that at least arguably, particularly if you focus on the use of identifiers that further narrow down the list, we're really talking more about differences of degree rather than of kind.
Reactions?
I'll just say I think it's a fair point. We could work on this more, but it doesn't. I don't know that there is strong evidence of the word relevancy being used in the statute to that effect. Obviously, the argument is that we've been doing this. We're about to hear from Steve. We've been doing it this way the whole time. That is not in the law. I mean, there's.
Well, I'm going to jump in and I just suggest that people look at some of the case law, including just from the D.C. Circuit, construing the very same term relevance in the Federal Trade Commission's statutory authority to issue civil investigative demands, which are subpoenas, administrative subpoenas, which do not require court approval. They get very broad construction from the courts in terms of what records they can get from companies that they think may have been involved in something, and those records go way beyond the scope of the specific issues.
As
I
you read those, think in terms of the FTC's hypothesis. When it issues those things, it has a hypothesis about something that's been going on.
I am getting the virtual cane around my neck to pull me off stage, pull us all off stage. So, Professor Rabkin, I'm afraid we'll have to break early. But please, in the audience, join me in thanking this panel, sharing their views on this important question. Thank you.